All right, this is 2509380M, the People versus Randall Crane. We ready on Randall Crane? Mr. Crane's coming up. Hey, you, Mr. Kazicki?
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett. I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding is on his own. There are some constitutional arguments that he's raising that I don't think as a member of the bar I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for them. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. That's a living name, not a corporate fiction.
So you're a real person named Randall Crane.
Okay.
Okay, no, listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
you have to provide subject matter jurisdiction as well as personal jurisdiction to me before these can proceed.
Okay, your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right. So, sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
my notes are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have a court. I can tell you can't have a phone in here.
Buckle up, guys. Today we're going to witness a textbook sovereign citizen meltdown in Judge Shackelford's courtroom. This sovereign newbie struts in thinking he's above the law, and within seconds it backfires. The judge doesn't flinch as the man claims he's a living name and tries to school the court on jurisdiction. That doesn't go well. This is a fiery opener, and Judge Shackelford is clearly not here for nonsense.
I want you to listen to me. You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense while operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options.
All right, guys, the judge is just getting warmed up. In this segment, we see the sovereign citizen try to inject chaos with more pseudo-legal lingo, but the judge steamrolls it with calm legal authority. He breaks down the charges like a pro, while the defendant tries to Google his arguments mid-hearing. Spoiler, phones aren't allowed. This is where courtroom order meets sovereign disorder, and reality slaps back.
Under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial. Okay? Those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those four options what you want to do. Hire an attorney, speak with court appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir,
exactly
here,
what-
can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your
Your
case
Honor,
back
I
up.
am asking for you.
Have a seat right now
What
and
was
read your
oath of
rights.
Office.
Have a seat.
Have a seat right now and read your rights, sir. If you
I
don't
read-
understand them, read them.
I move for this court to dismiss.
Have a seat.
Where is he? Okay, well, that might never happen, but, what was that guy's name on that file? Because I'm assuming did he leave?
Cream, you did.
Did he leave?
Yeah.
Well, he's big mad. Well, I need that file, because I'm gonna give him a bench warrant. All right. All right. Are you okay, Amy? Yeah. I'm coming. I promise I'll get to you real.
RFK Jr. is correct. Fluoride in water has hardened a lot of brains.
I'm just, you know what? I know I should be more patient. I'm so tired of the sovereign citizen.
This is where things hit a boiling point. The judge offers for clear options, but the defendant just keeps spiraling. No answers, just deflections. And when he refuses to cooperate, the judge shuts it down. He orders a man to sit, hands him a rights form, and prepares a bench warrant. The moment he walks out, you can feel the courtroom's patience collapse. This isn't justice delayed. It's justice denied by nonsense.
All right, we're coming back up. This is 2509380M, the City of Taylor versus Randall Crane. Mr. Crane, you want to come back up? Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you four options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney,
I understand that,
court
but
appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the four choices I gave you, which one would you like to do?
I am required to understand everything in regards to my case,
Okay.
including subject jurisdiction matters.
All right, well, you could do your
Personal
research. I'm setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do, waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in You're gonna try your case. Again, if you want to talk to House Counsel, you could do so. All
I'm
right,
not wasting the city of Taylor's time.
okay, good. We'll see you on your trial date. Have a good day.
He returns, but nothing changes. Randall is back in court, and the judge gives him one more shot. Instead of choosing a legal path forward, he drops another baseless motion, which is denied instantly. The judge finally ends the circus by setting a jury trial date and warns him not to waste taxpayer time. This moment is where power shifts. The courtroom tightens, and the judge regains full control.
We have a Samsung. It's either going to be Mr. Wiggins, or Mr. Walker. Let's see. There's somebody signing up for a pretrial. Screen name Samsung. There we got sound on Samsung. What is your name?
I'm Jonathan Wiggins.
Okay. Your ticket is 25R03001. This is a speeding ticket that was issued on the 9th of May at about 1:30 in the morning. You're eastbound 11 Mile in Lafayette. You were cited 35 and a 30. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Not guilty.
Raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Okay. The officer will testify first, please.
Your Honor, on the listed date and time, I was traveling eastbound on 11 Mile approaching Lafayette when I observed a black 2021 GMC Yukon traveling westbound on 11 Mile, eastbound on 11 Mile when I activated my front moving opposite radar and got a reading at a 47 miles per hour in a 35 mile per hour zone. I also observed the vehicle moving at a very high rate of speed, and that's when I activated my radar. The radar was tested before and after my shift, and I am certified to operate radar, Your Honor.
Thank you. Mr. Wiggins? Sir?
You want to hear my statement, is what you say?
Now we shift gears. Magistrate Chisholm meets Mr. Wiggins, a man with a speeding ticket and a story. He's 60, drives a Yukon, and swears he wasn't racing. His speech is raw and heartfelt. He paints himself as a responsible adult, just trying to get home from work. This clip shows a softer side of Courtroom, less sovereign madness, more everyday human drama. But will the story outweigh the evidence?
Yes.
Okay. I'm Jonathan Wiggins. I was coming home from work, 1:30. I take that route.
We've lost sound.
No, he froze.
He froze. We lost sound.
Let me see if I can go.
Do we have a phone number?
We do.
Your Honor, I'd like to just to clarify something. I was traveling, I might have missaid something in my testimony, but I was traveling westbound. The vehicle was traveling eastbound on 11.
I don't know what happened, but it just cut off on me.
Yeah, but we got you back.
Okay.
So where it left off was, you said you were on your way home from work?
Yeah, I get off at 1:15, and I take 11 Mile every day, and I know to do 35 miles an hour on 11 Mile Road and 45 miles an hour on Woodward. I don't have no reason to be racing up and down the street. I'm 60 years old. It was a car on the side of me when he was in front of us, facing us. And when he pulled me over, he said, "You know, you pulled me over for?" I say, "No, I don't." He was like, "You were speeding." And I was like, "Well, it was two cars. We were side by side on the lane. So how was I speeding?" And he said, "I visually radared you at 47. And I said, "Excuse me?" And at first he didn't have a radar. When I read my ticket, it says that he used the radar. And And then he said, well, I'm just going to give you a ticket for 1 to 5 over. I still take this route every day. I'm tiptoeing just to get to 75 so that I can get home. It's kids racing up and down Woodward and all type of sports cars. I'm not one of those. And I didn't like him saying that I was speeding. It was just too much for me.
Now comes a courtroom gut check. Mr. Wiggins is about to learn that sincerity doesn't equal innocence. The judge calmly dismantles his every excuse. Past speeding ticket surface. The radar device is validated, and the logic is bulletproof. 2 cars driving side by side doesn't make either of them innocent. This is a masterclass in courtroom reasoning over emotional storytelling.
What's that got to do with the rate of the vehicle?
I was doing 35 miles an hour on 11 Mile Road all the way to 75. I don't know how he clocked me at 47. It was 2 cars. It was me and another car. We were side by side.
Maybe both of them were speeding.
Why does that show that you weren't going 47?
He was in front of us.
The officer was opposite direction.
Yes, he was facing us. Yes, coming from another direction. Then he turned around and got behind us. Got behind me, and I saw him. So I'm still doing 35 miles an hour down the street. Then he pulls me over. He had the time to read the 1 car plate next to me, and he had a chance to read my plate. He pulled me over and said that I did 1 to 5 over, but I was really doing 47 or something. And I take this route every day. I work at the hospital. I have no need to race. I have a big Yukon truck. It is not a race car. And I don't drive it like that. I don't have any tickets for speeding or none of that. Never. I haven't had a ticket in almost 20, 30 years. So to hear this was kind of like, wow. I'm saying I'm not guilty on the speeding charge down 11 Mile Road. I know the law on Woodward and 11 Mile Road. I do. And that's a chance. You just speeding down 11 miles, doing 100 miles an hour to get to 75 is crazy. I would never do that.
The verdict is in. The judge finds Wiggins responsible for speeding, reduces the points, and explains why this ruling is both fair and factual. The excuses fall flat, the radar evidence holds, and the law does what it's meant to do. Apply the truth without bias. This final part reminds us that respect, honesty, and facts go further than any script. If you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.